familiar face. And, for anyone who's not aware, we sort of tend to do this once in 2 months. And this month, we usually tend to have subject matter experts coming in and talking about specific topics, just because I think that's just been more popular of late. This month, however, I am going to be honest, I have struggled to find a speaker, just because I think people are away on holidays or what have you, but the timing was just not working out for a lot of people that I approached. So it's the Q&A this time. So I do have a specific question on restrictive covenants. So if anyone else doesn't have anything particular, I'm quite happy to open the meeting with that question. Just let me know, but obviously you come first. So let me know if you came prepared with any questions.
The only thing that I had, I'd be interested in a point of view on is, we come across this quite a lot with HR consultants, and I'd be interested in the employment law view. When we're advising clients, as employment lawyers, your advice that you give is protected. But I don't know that HR consultants don't have that level of protection. So how do other people go around giving advice to their clients and getting that protection in place?
Is that a question for other HR consultants, or are you just
and from employment lawyers? What's the suggestion for HR consultants that are giving advice as to how to afford yourself that level of protection?
I don't mind jumping in with that for starters, see what everyone else's view is as well. You're right. One of my HR colleagues, I'm an employment lawyer by background, and I've got my bit of paper that still gives me that extra protection. One of my HR colleagues used to say it's a bit of a closed shop. The legal profession gets this extra protection in the context of giving or receiving information for the purpose of giving legal advice. It does have that legal privilege in a lot of cases. It's not automatic, but as long as it's broadly for the purpose of giving or receiving legal advice, it gets sort of locked away. I always think, though, in terms of how can HR consultants get that same level of protection, it is hard. We are operating in a closed shop as the legal profession. Somehow or other, over the years, people have believed that lawyers must be more trustworthy than anybody else, so we can get locked away. But I kind of think, for me, the best guidance is, it's not great for clients, but obviously to almost give the anonymous approach. Sort of, if you were having the conversation in an open plan office, the kind of conversations you'd have would be, oh yes, the employee we've spoken about, or that employee in this department. I know when I've given advice sitting in open plan offices, when I've worked within the HR department myself, even your HR colleagues aren't always aware of who it is you're talking about, and so you just have to sort of speak in code a little bit, and I think initials are not a great idea, because of course it can always get picked up in a DSAR, any initials that are obviously relating to an individual. And so I think that's the best solution if you're doing emails, is just sort of it's just a reference, the employee we spoke about at 10:30 today. Here's my advice in relation to what do we do. Even that isn't guaranteed, because you just need someone to then get a DSAR for that diary entry at 10:30. There's a risk then that anything that's linked to that it can be identifiable. But having said that, it's going to be hard to find that email on an electronic DSAR search. So yeah, I think that for me, that it's almost treating your emails and your documents as though you were having a conversation, in a corridor, in an open plan office. As humans, we are able to sort of find a different way of trying to describe who it is we're talking about. I think that's the only obvious solution that I tend to give, and that I've seen others adopt. And of course, it's about educating, isn't it, as well? So I think in my role, I've seen plenty of DSAR results that for me to review before they go out, and of course you just cringe. And I know that I'm lucky because my emails get removed, and I look at my own emails and go, oh, wish I hadn't put it quite like that. In cold light of day, it just looked it kind of could look a bit wrong. As I say, I'm lucky because I can take mine out because of their legal advice. But you can see that, kind of, yourself when you're emailing or corresponding about someone. Obviously we're, generally in, we are a bit more clued up to how careful we are of how we describe things and what we put, and we're more clued up to the fact that they could get disclosed. And therefore I think, it's getting that wider education to make sure that people don't put things that are too identifiable, certainly don't put things that are derogatory, make everything factual. But yeah, I think it's assume everything could be read, and assume that someone's listening, and therefore how would you anonymize the way that you're speaking about them in such a way that helps the client as much as possible.
Yeah.
But it is hard when it's anonymous, and it reads really badly. But it's sort of, how do we, I can't think of another solution. Be interesting to see.
It's not necessarily because I've said something or we've said something derogatory. It's where you're giving to kind of, you're explaining the advice, and that why you're suggesting that particular path to afford protection to the employee, or you're highlighting a particular risk or something like that.
Exactly. Yeah.
Which generally we do that anonymous. But what I've had recently, as much as I'm fighting, clients are coming back and going, "Oh, Sarah that we were talking about," and you're like,
yeah, it just destroys. Exactly. Yeah. No, you're absolutely right. And it is those emails that say, we've created a big risk here, probably best to try and settle. And that's the last thing you want the employee getting hold of.
Exactly that.
And it is tough. I think one thing that I see when I've worked in legal teams before, and there must be a setting, because one of my former colleagues who does general sort of commercial litigation, she has her email set up that she hits reply, but instead of it being a chain, it attaches the previous string as an attachment to the email rather than in the string. And she always says that's to make it, that's to sort of keep privilege and everything that's there, because it's then not all on display in one go. And I don't know how a DSAR would cope with that. And I'm not even sure how to do that setting. But you're right. It's, I guess for me, it just comes back to that education piece, isn't it? You've gone to all that effort to call out a risk, or to give give you your best advice in a way that wouldn't be seen by the individual, and then it's ruined when the client doesn't get it. And it's that phone call to say, look, I'm going to write this as though we're in an open plan office. Can you make sure your replies are along with the same mind? Because it is just that broader education. And
I quite like that visual of writing it as if you're an open plan office.
But I'm interested to see what everyone else's thoughts are on that, because it's definitely, it does crop up. Absolutely. That email, as you said, it says we should settle, or we should do it one way, and and then they don't do it that way, and it's sort of, then it's all laid bare, isn't it?
When I'm speaking to clients, I on a contentious issue, I always remind them that, and I as a HR consultant, not a lawyer, I just say, don't put anything in detail, and I even go a bit further than Paul's discussed, because anonymizing it, you will always be able to find out who, if you were to do a deep search as to who they're referring to. So I just say to them, assume that anything you put in email is discoverable. And I literally just say, just don't put anything in email until we get right to the end. And if we want to just, confirm final things with each other, we can, but don't put anything in email. But like you say, I like you both said, that usually that gets forgotten in the heat of discussions. So.
Yeah, well, it was a situation where we had a call with a client. This came up again. It came up again recently. We had a call with a client, and obviously on the call, everything's spoken about freely and openly. And then we put in place the advice that we talked about, the agreed procedure that we'd talked about, and then they asked afterwards for a summary of the call and what we talked about, and you're kind of going, well, that defeats the object of the call. So we just said, look, this is the advice as agreed in the email, and moved on. But it's a question that I always wonder how others deal with. So
it just made me think, most of my clients are financially regulated businesses, and I've just realized I don't know the answer. Most of them are on recorded lines because they're FCA regulated, and I'm wondering if those conversations are discoverable as well. I don't know the answer to that.
I've worked in financial services as well, Mike, and I think generally what it tends to be the customer lines that are recorded. I know I found out once that my phone number had been sort of lumped into the recordings, and we got that stopped straight away because the back office stuff doesn't need recording. I suppose technically they would be. I mean, they would certainly be discoverable from a litigation point of view. I'm not sure. I mean, even if they were discoverable from a DSAR, they would never be found. Unless they were transcribed somehow. There would be no way of searching the tapes, and actually, it wouldn't be a relevant filing system because it would, be. And I say tapes, I'm showing my age, but the tapes would be, kind of a week's worth of calls that were discussing all sorts of bits and pieces.
I'm just thinking of matching up a call log from my number to a client, and the client's a client, and then I don't know.
Yeah, I think there would be
the others think as well. Sorry.
No, it's definitely a good one it's a great question, Sandhya, to get everyone talking. I think they would definitely be discoverable for litigation. I don't think they would be required to be disclosed on a DSAR because too much effort would be required to find them, even by looking at the logs. I think Mike to spot, this was a call that we had with Mike doesn't naturally doesn't automatically mean that it was about Joe Blogs. It might be about arranging a networking lunch, for example. So that's my view, but I think it would probably be discoverable on litigation. I think there may be an argument that it would be a reasonable search to do because the person the internal HR person or internal business leader knows they've had a conversation with you about Joe Blogs, and therefore ought to be able to get the logs. But yeah, my starting point on that would be if back office calls are being recorded with senior leaders and HR teams, then probably someone needs to have a look at that.
Isn't there a requirement, and this is actually more a question for the lawyers in the room, isn't there a requirement that where there is, say, a court order saying, I just want everything disclosed in relation to this matter, then obviously where we would have to go back and, like you say, Paul, disclose all the call logs, isn't it? We'd have to do a search and discloses all of that. There would be no question at that point. But I suppose the question there is whether it is possible and how much of it is going to be recorded or not.
Yeah, I think it would be a reasonable search from a litigation point of view to undertake that. But I think that would only arise if it was, I don't know, if there was whoever it was that was on the call had been notified by the litigation team, by the way, John, can you get all your data? Yeah. And John then has a note that says, oh well, I spoke to Mike about Joe Blogs on this date, and then it's in a sense at that point it becomes obvious. If we know the line is recorded, then there must be a log to go and find because we know that John spoke to Mike on this day about Joe Blogs. But I don't think that's the same as there must have been a call that John and Mike had about Joe Blogs. Let's go find it. Let's get someone locked in a dark room to listen to weeks worth of phone recordings. So I think so only if there was, if John was the person that had been asked by the litigation team to find something, and he had this note that said there was a call about Joe Blogs,
you'd have to disclose that
when it was and where it was. The note, of course, would be disclosable. But if it was just like many of us, it's maybe there's a date on your note. There certainly wouldn't necessarily be a time for when that happened, and so I think there would come a point when it would cease to be a reasonable search. If it's going to take several days for someone to go, okay, well, we know during that week John and Mike had a call about Joe Blogs. I think that would be harder to show that was reasonable. Equally, I can certainly think if you were the lawyer acting for the company, you'd want to get hold of the transcript of that call or the call recording to listen to it. Just so you'd want to know, because if it was helpful, you'd gladly disclose it, wouldn't you? And if it was unhelpful, then you've then got better information to be able to advise your client that perhaps things aren't quite as they seemed. But I think it would be disclosable if it was a reasonable search to undertake, and I think that would only happen if it was real clarity of when the call took place, and there was definitely discussion about Joe Bloggs on the call, in my view.
Does that answer your question, Matt?
Yeah.
Good. Okay. Speaking of
Could
recordings,
I
I've just
Sandhya,
sorry.
can
Of
you hear me
course.
okay? I'm trialing some new kit, so it's all very
Yeah, I can hear you very
I've
well.
no idea if you can hear me. So can I just add to that, because I think it's right to say there's a two-tier system. So HR consultants would not have the protection, the privilege afforded by both legal professional privilege and litigation privilege. So in both instances, there's a vulnerability there. And certainly lawyers will attack that if they're acting for claimants, because all advice is therefore admissible, potentially admissible in proceedings. If you're talking about litigation, the question in terms of disclosability and discovery in that sense is whether it's germane and material to the issues in dispute in the proceedings. So, for example, with litigation involving discrimination, it's very rare that you've got an absolute slam dunk case of discrimination. What you're often looking at is conduct or a series of issues, and what you're seeking to draw from that is an adverse inference that actually this was all discriminatory, and sometimes you're looking at the last straw and so forth. So there, what you're looking at is building up a picture, and therefore you might go searching for documents. And of course, the counter argument is that's a fishing expedition, and you've got to be a bit more precise about that. But the starting point is, if it's employment advice which is not given by a lawyer, it could be open and it would be admissible if and to the extent you can get hold of it. The data disclosure point, I think Paul's absolutely right. I mean, it depends where, of course, you've got sufficient details, you can find it, how much effort's involved, whether it's disproportionate and so forth. And of course, if you anonymize things, they're not going to be those biographical details that enable you to. So even though it's quite clear who you're talking about, it's not going to be disclosable because they're not identified and it's not their information as such. Obviously, the main way you would, or I would suggest that if you're getting close to discussing a termination, is directly in correspondence. You can put things on a without prejudice basis, and of course use the section 111A of the Employment Rights Act. But the advice leading up to it is the danger zone, because that's where the minefield is, because that's disclosable, and that is where you're vulnerable, because that's what lawyers would seek. Even though it's anonymized, there's going to be that vulnerability that it's susceptible, because it would be unusual for an employer who has recourse to advice but doesn't consult solicitors to have very well drafted letters and procedures that they're following. The very clear inference is they're taking advice. And if they then say, oh, no, we're not going to disclose that, that would look like unlawful withholding of information, and it would make you vulnerable again to those accusations that there had been bad faith, and that could be used both in sort of grievances, complaints, and of course litigation. So I accept everything Paul says. I think that's right. In practical terms, that's probably as much as you can certainly do and you should be doing, but nonetheless there's that susceptibility, and it is vulnerable.
Yeah, thanks a lot, Chris. That's a really good point there. In terms of audio, recordings, just one thing that came up in my mind when we were talking about this, not so much related to HR consultants, alone, but increasingly we're seeing staff raise the question saying, and it's usually staff will get really stroppy and say, oh, I want to record this conversation. I want to record this meeting, even though it's very clearly outlined in the handbook to say we don't record any meetings. We take handwritten minutes, and you are welcome to take your own minutes. And one of the things I tend to tell my clients, because we, having had firsthand experience of this, just because of when I was working in corporate and where I did attend tribunal on behalf of the company, and the judge really frowned upon any kind of recordings. He didn't want to know, he just didn't want to have any recordings as part of the bundle at all. So my question is, how, are you quite confident, and do you just say, no, sorry, no recordings? How does everyone deal with it?
Yeah, I just say no recordings.
Yeah.
Unless
the
there's a particular circumstance. So I guess I have allowed recording, but only when someone wanted to move forward with a meeting, but they weren't able to be accompanied because they couldn't get someone, they were off sick. And so it was more of a it was a grievance hearing. So I let them, I recorded that meeting.
So my rationale is, it's just not company policy, and we don't see a need for it. It's not going to have a material outcome to the meeting, and so written notes, what I'm going to be taking, and you're more than welcome to take your own notes. But that's as far as it goes, and that's the reasoning I give them, saying it's not going to have any material impact on the outcome, and it's not part of the policy. And if somebody is going to press further, then my stance is, well, we just have to suspend the meeting here, because if you're not willing to play ball and cooperate with what you're being asked, which is pretty reasonable under the circumstances, then we can't carry on with the meeting. Come back when you're ready to take sort of minutes, and if somebody can sit down with you and take minutes, if you're not comfortable doing that, we're more than happy to allow that as well. So yeah, just trying to understand. But is there a question
as to why you wouldn't? I always struggle. So if someone's being particularly pushy on wanting to record a meeting, then I guess the question is, why wouldn't you?
I think it's just because it just impedes communication. I find that managers tend to stiffen up, nobody's talking openly, and you don't end up saying what needs to be said, or thinking clearly about what it's almost sort of an impediment to your thought process. I don't have a problem, like, for example, this meeting is being recorded and we are all talking, but I think there are some managers and even some representatives who are sitting with there, they just stiffen up and don't want to speak and don't want to say anything, and because they're also unsure of what's okay or what's not. For example, when you're sitting with a manager and you're running a meeting, right, a question comes up, say it's an appeal meeting, and the employee pulls out another piece of evidence, and the manager who's chairing it goes, what am I to do? And they don't want to say, what am I to do, in the recording. Whereas if it was not being recorded, this is Sandhya, can I have a word with you, please? Can we adjourn? They will ask the question more openly. And I've literally seen this panning out in both circumstances. I don't think it's fair. If there is no need to record, if somebody is able to write it down, and if somebody is able to, if you're even willing to allow a companion to write down notes on your behalf, I can't see the need for an audio recording. So that's my rationale, really.
I guess there's sorry, go on, Paul, were you going to talk?
No, yeah, you were first. Go ahead.
Okay. I was just going to say that I think there's also an argument, I suppose, around confidentiality and being able to control that recording, because actually,
absolutely,
if you've got agreed notes, that's one thing. If you've got a recording, that can go anywhere, that can be cut up in any way and taken out of context. So I suppose that's another. I record quite a lot of meetings that I do, because I'm relatively confident that I'm not going to say anything prejudicial. And also it's cheaper for clients for me to get that recording audio transcribed by someone, and that becomes the minutes, rather than me spending the hours that it takes. Usually I say it depending on the length of the meeting, it takes about double the amount of time that the meeting was to do the notes of the meeting, and so that's a cost for the client, I translate. But equally, I understand where you've got a manager who might not be quite as cognizant of what they're saying or how that might be perceived. There is a risk there, and I think that confidentiality point is probably where I would go in terms of being able to control the information.
Yeah.
There is a case. I was trying to look up the name of the case. I can't remember it, but it was to do with the post office, and it was a postman going through a disciplinary procedure, and he covertly recorded the meeting, and he left his phone in they adjourned, and he left his phone in his bag recording the conversation between the manager and the HR rep in the room, and he was able to use that recording as part of his evidence to say, look, they were discussing his union membership and his union activities, and he made the argument that that was a leading driver in his dismissal, and the judge accepted that evidence as part of, you know, so even if you're not recording the meeting, you might be being recorded anyway.
I think, Ben, that was going to be sort of my point really. I'd forgotten that case. You're absolutely right, and because the reality is, the tribunal doesn't, you know, tribunals never really care how evidence comes about. If it's relevant, they'll hear it. You know, they're nowhere near as strict as sort of a commercial court would be. And I generally advise managers to assume they're being recorded anyway. You know, actually, the times that the employee asks you, they're being polite, because frankly they'll record it whether you agree or not. And I think all the points we've made about why it's not a good idea, definitely valid. I generally recommend, look, try and be as persuasive as you can. Give them all the good reasons why recording is just not helpful. But fundamentally, there's enough to fight about in a lot of these conversations. Does it really matter that it's being recorded? I tend to advise, look, you know, even if you say no, the chances are they'll record it anyway. So why have that fight? You know, try and have the persuasive conversation, but fundamentally, if it's getting in the way of just getting to the heart of the matter, is it helpful to start the conversation with a fight when the fight can come later about the actual facts that are at play? You know, why get everybody off on the wrong foot if you don't have to? They'll record it anyway. You know, where I definitely draw the line is, even if it's recorded, we're never going to transcribe it. If you're making a recording, do your own transcription. By all means, use it as your own aid memoir, your own opportunity to disagree with the notes that we're taking. But our notes will be the minutes of this meeting. If you're recording, in the olden days when these things happened in a meeting room, if you're recording, don't leave this room until you've made a copy and left a copy with us. So we always keep, you know, I would always recommend that we keep a copy of whatever they've got. Not necessarily to listen to, certainly not to transcribe, but just so that we've got sort of the original copy before it's gone away and been tampered with and created, you know, kind of something new created. But I tend to say, like, you know, absolutely try and persuade them to not record it. Make it clear our notes are the notes. But if it's getting in the way of the hearing, just crack on. What does it matter? They'll record it anyway.
I do usually start a meeting saying this meeting isn't being recorded, and you know, so it's very clear that if it is being recorded, that hasn't been authorized by myself. Yeah. You
may want to add, we are not recording this meeting, and we would ask you to confirm that you're not recording.
Yeah.
Because then that way they have then actively said, I'm not recording it. So I think if they then at a later point come up with a recording having confirmed said to you they weren't, that would diminish their standing.
Yeah. Although based on the post office, it's not.
No, and I think
well, it's not. And
I'm
quite, Ben, it'd be lovely if you could just send us the name of that case law, please.
Yeah,
because recently I had a case where my client was holding the meeting. It was a short service dismissal. Yes, there was issues of cancer, but there was also unauthorized absence hiding within all of those absences. So anyway, my client had enough, and we, you know, there was a termination of contract that took place. And this employee, of course, my client thankfully didn't say anything untoward, but much to my client's annoyance and frustration, he discovered that the employee, against his wishes, had, against my client's wishes, had actually recorded the conversation. And at the appeal, the employee said, I've got the recording, I can share it with you, because I was going to hear the appeal. And I spoke to my client, and my client goes, we very specifically said no recording, Sandhya, and he did it without my permission. What about, our rights as an employer? And that's why I just thought I'd throw this question out here to ask, really. I mean, and I thought my client was right. Where we talk about privacy and data protection for everybody else, when a client as an employer has categorically told an employee no recordings, and you clandestinely do it, I said, sorry, I can't include your evidence, recording. I'm looking at the minutes, and this is your appeal.
So please come and add whatever you feel is valid, or to this. But I'm sorry, I can't admit your recording. That was my stance.
Can I just say, Sandhya, on that? I mean, I agree with that. There is a distinction between sort of pre-action and litigation admissibility here, because my experience is employment judges are always likely to allow in anything which is a contemporaneous piece of evidence if what is in dispute can be clearly put in that context. Whereas if it's just a very detailed note, it's a transcript of, and it's a very, very detailed note, it's got more detail in it, but the minutes of the meeting are not inaccurate in any way, but there is some outline, nobody will care. And then the judge will say, no, I'm not interested. Are there any points you want to take me to? If not, thank you very much. Bin it, because it's not germane to the points. My take on it is it's perfectly reasonable if it's in accordance with the say grievance policy or disciplinary or even any form of investigative matter for an employer to say, we do not, it is our policy not to allow these meetings to be recorded. We don't record them, and you as an employee may not record them. And therefore, if that's a reasonable instruction and it's contractual, it actually is a breach of contract. That might be useful, as Paul was suggesting, to show and highlight a lack of cogency or even the beginning of a breakdown of trust and confidence. It also, possibly down the line, enables you to say that the employee is not always credible on what they say, particularly if they've said they're not recording it, that actually it casts doubt on their veracity. And so those sorts of issues can be deployed to the employer's advantage. But the starting point is they should be able to enforce their contractual terms. But sometimes the practical circumstances are, it just happens. I mean, particularly nowadays with remote meetings, that's when you're face to face, you can see if somebody's got a bag and they're sort of leaning down and putting now turning the phone on. Okay, here we go. Just reaching into my pocket, I'm just adjusting the jacket. Or it's kind of familiar territory. But in this sort of environment where we're sort of looking at a screen, you've got no idea what somebody's got going on, and that is susceptible to hidden recording. But like Paul was alluding to, you don't need to make it a fight if actually you can just make the point. It's destructive, it's counterproductive behaviour, and you're not going to sort of pay any attention to it and just move on. I think I would pick. There are normally bigger fights, aren't there, down the line?
Sure. Yeah, I think the one point for me to take away is, yes, I think that the grievance and disciplinary policies are not contractual. They are in the handbook. Having said that, so my point is I couldn't have said breach of contract or, in that particular context. But having said that, it's very, very clearly outlined under the policy in the handbook to say we do not permit audio or video recordings of meetings, but online meetings will be held. Ben, thanks for that. I think you've just posted something about the case law, have you? Just seen something pop up. You're on mute, Ben.
Yeah, the first one that I posted, I'm just going to post another one as well, but the first one I posted is a case where they didn't allow a covert recording because it referred, in the conversation that was recorded, they referred to the legal advice that they'd got, and it was deemed that then had legal privilege. And the second one I'm posting now is the post office one where they did allow it.
Thank you. Thanks for that. Okay. Any other points on that? I just, if there were no other questions, I'd just like to throw one more question into the ring. Restrictive covenants. I know we kind of, this has been bashed about quite a bit. It was, I think it was many years ago, people used to include covenants extending all the way up to 3 years even. And then more recently, it said reasonable can only be between 6 to 12 months. And very recently, I've seen communication come through which said courts are considering restricting it, any kind of restrictions should only be in place for no more than 2 months after an employee has left the business. Now, I'm just thinking of the practicalities, even if it was 3 months, even if it was 4 months, I'm just thinking of the practicalities for clients, especially who, one of them is financial services, the other one being your sort of salon down the road where the receptionist has all the information on client database, and they decide to go down the road and set up a nail spa, and they kind of, or even a salon, a similar kind of structure. So I'm just thinking, where does this take us? If you're talking restrictive covenants for just 2 months, is it useful at all? Should we be, or do you think it would still act as a deterrent for somebody to go away and try any hanky-panky? Mike, you just seem like you want to say something.
My answer to your question is, what the answer I give to clients on this is it depends. And in general, I think I always say to clients, it's got to be proportional. So I think in your example of taking the information, that's probably covered under other, that's covered under confidential information. But I think I tend to say to clients that the more restrictive, the wider the restriction, the longer the restriction, and the more junior the person, the less enforceable it is. And therefore having and also the restriction, the one thing that clients seem to want to try and include is restriction on working elsewhere. And I've said that I think that is, in my experience, that's the most tricky and the least likely to be enforceable. Whereas the other things are more likely to be enforceable. In fact, the restriction on working elsewhere I think is almost unlikely to ever be successfully enforced, pending some really specific things for very senior, very specialist people. And even, I think if what you're talking about, I think, is the government talking about whether restrictive covenants are restricting the movement of labour. And I know this is a big thing in the US as well, but I think that mainly applies to not, restrictions that say you can't work elsewhere, which I don't think are often relevant.
No, this is not so much to do with not being able to work elsewhere. I think that this is more to do with typically small business owners feeling threatened by employees going and setting up a very similar business down the road, less than 2 miles away, less than a mile away, and then kind of poaching on all your clients and on your contacts, especially if it's somebody like a fundraiser, for a charity, especially if it's somebody like a receptionist for a beauty salon. And these are real cases which, again, I've had clients, they've been exposed to it. So
it's a real challenge, this area, I think.
Yes, and so the question really is, and normally, and you're absolutely right, Mike, any restrictive covenant has to be specific to the job role. It's not a restrictive covenant for a company. So in that respect, you look at the seniority, you look at the kind of data they hold, you look at all of that, and it's got to be a very bespoke restrictive covenant. I get that, but the question is more to do with if there's going to be a cap saying no restrictive covenant can extend for anything more than 2 months after the date of termination. Really, what's the point of even taking the time to draft one, is my question. And do you think it's worth the paper is written on? I don't know. This is why I thought I'd just ask the question. How are you protecting the business if you can't put a restriction for more than 2 months?
I think you'd probably argue as well, Sandhya. I think that the value in the restrictive covenants is its deterrent value, because actually most small businesses can't afford to enforce them even if they wanted to. The cost of doing that, the speed with which you have to move to get your interim injunction in place is just prohibitively costly. I think Mike, you're right. I think the consultation the government's doing is non-compete only, and who knows what the outcome of that will be. And of course, the drafting of them is really important. Garden leave is the only thing you've got to just remove someone, but then can the small business really afford to pay someone to be at home for 3 or 6 months doing nothing? But I think unless someone is kind of moving, opening up next door in abject and kind of pejorative breach of their covenants, businesses, it's just a risk of the business. And I think the better, obviously the more enforceable the clause is likely to be, the more reasonable it will seem to be to the employee as well, and therefore its deterrent value will be greater. So having a 12-month non-compete and a 2-year non-everything else, it's never going to be enforceable for for anyone other than executive directors of major PLCs. And employees will know that it's just ridiculous and it interferes with their livelihood anyway, so they're just going to breach it. Something a bit more reasonable, maybe it's a 1-month non-compete and a 3-month non-everything else, might be more enforceable. Well, it certainly will be more likely to be enforceable, but what it will be is it will seem more reasonable to the employee. And so I think, certainly when I'm drafting contracts and when I'm advising on this kind of thing, you're always going to say to businesses, look, there's no guarantee this is enforceable. We'll draft it in the most enforceable way. Even if it is enforceable, it's going to cost a fortune to enforce it. The most important thing is, it comes back down to building the right employee culture, doesn't it? So of course, having the clauses that look enforceable and seem reasonable, so the employees don't want to breach them, and it's treating them well enough that when they leave, they don't have front of mind, how can I screw over the person, the people I've just left. So I think maybe that's part of the answer as well, is encouraging the right cultures both ways. But I think you draft them as enforceable as you can, and there's never any guarantees. But even if they're cast iron guaranteed to be enforceable, it costs so much to enforce them. So I think it's getting the deterrent value right, I think is sort of my approach with these kind of things.
I'm smiling, Paul, because you mentioned the word deterrent, and I thought I was the only person using that. I'm so glad that all my HR colleagues in the room have been there and have used the same word. I'm thinking, thank God for that.
Definitely.
I'm sorry, Nicola, you were saying something.
Oh, that's okay. No, I was just going to agree with Paul. I think the reasonableness that you show to your employee that's exiting is likely to have a better outcome for everybody anyway. So I do think that's a really important point, that you do want to obviously stop people taking the business that you've worked all those years to build up and all the clients and contacts. Of course, people want to protect that. But if people feel too restricted and they're too onerous, they're just not going to pay any attention to them, and I think they're just going to say, well, let's see what you do about it, and I'm going to do it anyway. So I think it's important, as you say, with the culture of the business, if they've got a good relationship generally. I mean, not everybody that leaves a business is leaving on bad terms. They could just be, it's career progression, it's a different field, whatever they might be doing. So it's good to leave on a better note, I think, because my experience of restrictive covenants is that even if you send a letter, a warning shot to the former employee that they're in breach of everything, most of my clients don't take action because it's just not viable for them commercially. And I think employees know that as well. So that I just wanted to add. I was just agreeing with what Paul believed in that respect.
Oh, thank you.
Well, Sandhya, if you've got a receptionist at a nail bar probably being paid minimum wage, or maybe not even being paid minimum wage, it's going to be pretty hard to argue that they've got to have a restrictive covenant for anything.
I think in this particular case it was just a question of the receptionist having a lot of all the data, basically the customer data, and very good relationships with every customer coming through the door. And obviously this is an example of the client coming to me after the horses have bolted, really. So and yes, of course, she went in the same village, set up another salon, and it did impact the client's business big time. And she'd been an employee for about 17 years within the same salon, so you can imagine there were very healthy customer relationships there. So but yes, I think it can be, one has to look at the role and take a realistic approach to how long it can be.
Yeah, can I just add to that, because I've not encountered a 2-year threshold, 2-month threshold in any cases I've been dealing with recently. I think certainly the route of travel, the government scrutiny is to limit anything that's anti-competitive. It's very laissez faire economy, and post-termination restricted covenants, and that's what we're talking about, post-termination, not in employment restrictions, are specifically anti-competitive, or they should be in order to be enforceable. But you're still going to be looking at the temporal and the spatial boundaries, and they're only going to ever be protectable to the extent they seek to enforce a legitimate and proprietary business interest. And they're going to be one of two things: customer influence and confidential information. They're the two pegs you put the restrictions on. And so somebody's walking out the door, even at a low level, receptionist in your example, with information that is proprietary to your business, that could be destructive, that could be damaging. You don't necessarily need to rely on restricted covenants. I mean, you just simply go after breach of fidelity and confidence. I mean, that's clearly, you'd get a springboard injunction for that without recourse to anything expressed in terms of non-solicitation or so forth. You know, you just wouldn't need, you don't even have to say non-dealing. I mean, you just simply could nail that. But Mike's right too, that every matter is fact sensitive. They all turn on their individual circumstances, and you have to balance what are competing interests, which is the interest of the business against often the interest of the individual, which is to sort of scamper off in the other direction and sort of start their life afresh. And you know, the question is, what do they draw through with them? You know, if they've sort of downloaded, and you can see that they've downloaded every single precedent and all your data files and all the contactable client data, that's likely to be a really big red flag, because that can make your business very vulnerable. And normally you should only have restrictions. You should have certain tiers of restrictions for different layers of seniority within the organization. So I've personally not encountered, say, a receptionist having restricted governance, but I can imagine that there might be.
Since then, the clients started having one. I mean, yes, they do have it to receptions. But going back to your point on the injunction, Chris, is that something that an employer lawyer would do then? You know, the injunction that you just mentioned, where, you know, for breach of confidentiality, and that you don't need a restrictive covenant. You mentioned that you could get an injunction in place. So just for
you can always
future reference, is that something an employer lawyer would do?
This one does, and you can always go for a springboard injunction, regardless of any contractual restraints in the contract of employment. So you bypass any arguments as to proportionality, reasonableness, whether they're limited sufficiently, concise, and go no further than reasonably necessary to protect the legitimate proprietary interest. You bypass all of that if you show somebody's stolen your data.
Yeah, okay.
Because the nature of the injunction and the relief that you're seeking is that what they have done is so abhorrent, it ought to be, you deserve protection, and the law will respond to that. Yeah. I mean,
Chris,
I'm just trying to understand which section of the law that would come under. So when you say a springboard injunction, that employment law, yeah. Thanks. Yeah, okay.
Chris, I've not heard of a springboard injunction. Apology. Can you just explain again what that is?
Yeah, it's a common law right for any party where the other party is in repudiatory breach to seek to enforce it and to prevent the essentially, literally, I think probably it was first road judges dealing with accepted the principle that it's to stop somebody gaining an unlawful springboard from their sort of, what is often a conspiracy, that they're being tapped up by the new employer and said, if you can bring those customers or that information or whatever it might be, often it's a combination of the two, isn't it? And you can promise to deliver that, you'll come here and, the grass will be very green. So
can you also
stop that?
I'm sorry, Chris. Did you want to just finish off what you were saying? Sorry.
No, I've been talking for.
No, because I have a question on. No. It's really interesting because you obviously mentioned something that even like Mike, but I wasn't aware of a springboard injunction. But the question now then is, can it also be used when a disgruntled ex-employee goes off on a social media rampage about the employer, like left, right, and center? I mean, I think I brought this to the roundtable about a year ago, where it happened to one of my clients again. Can it also be used in those circumstances? Obviously, I'm assuming it must be really expensive to even get one in place, but just good to know.
I think you're talking probably about different issues, and that would be distinguishable. If you're talking about defamatory, negative, inimical comments
on social media,
you can potentially restrain somebody in the usual way, but you're coming under defamation and libel and that sort of situation. That's not an unfair springboard, and it is not. But it may be a breach of an express restricted covenant. Often you'll see a restriction that says after the event you won't hold yourself out as being connected or associated with that business, nor will you make any derogatory comments. I mean, it's unusual, but you do see it. But I think it would be a different area of the law. It would be the general right, even for companies, not to be defamed and not to have their business slagged off, if you like, particularly if it's malicious. That would be a tipping point there.
Yeah. Interesting. Always a school day in HR, like they say. I'm just conscious of time. We've got 4 minutes left for our meeting. And I just wanted to say a little bit about our next round table. We've got an interesting, don't know whether you've heard of Finwell, but I've invited them to come and talk about financial well-being within the workplace, because yes, I think since lockdown, we've spoken a lot about mental health of the workplace, but I think it's clear that people want a more specific, bespoke approach to what an employer really means by well-being initiatives. And over the last few roundtables, I know we've spoken about different topics specific to what well-being really transforms into for an employee. But I just think, given where everybody is with sort of the cost of living index, financial well-being, they're very good at engaging with employers, and not just employers, even schools and organizations in the community. So it'll just be good to kind of bring them to the fore, I think, and have a chat about how they can engage with all of us and how we can kind of take that message to our clients as well, to see if anybody within their staff can benefit from it. So they're going to be our subject matter expert next. I think it's in September, isn't it? We're in July, August. Yeah, it's September. So just thought I'd let you know. But obviously, any questions in the meantime, just send us. And also, what will be helpful is if you would like a specific topic, a subject matter expert invited to the group, please could you write to Catherine and me? That'll be really helpful as well. And we can try and get everyone lined up for our future events. Because what we've also gathered is we're going to try, and I think we have 6 roundtables in a year. So given how popular these conversations tend to be when we have a subject matter expert, we're kind of focusing on about 4 to 5, or maybe 4 subject matter experts in 1 year, and then the remaining 2 being sort of open-ended Q&A sessions. If everyone's happy with that, does that kind of work for everyone? Okay, so yeah, but definitely please feel free to send your thoughts on who you think could, what topic really, because then leave it to me and Catherine to try and figure out whom we invite. But if you would like a specific topic being focused on, please try and share that with us. Okay, lovely. Good to see everyone, and hopefully see you at the first Wednesday next month. In the meantime, enjoy your holidays, survive the summer holidays.
Thank
Thanks,
you.
Sandhya.
Thanks, Sandhya.
Bye.
See you then.
Bye.
Bye. Bye.
Bye.